There's a new law in New York State designed to put guardrails around litigation funding. What does that mean and how effective will it be? May it please the audience. I'm Rich Schoenstein, and this is So Sue Me, the podcast about civil litigation. And we have today a brand new law signed by New York Governor Kathy Hochul. The law is called the Consumer Litigation Funding Act. There you see a picture of the governor. It has been signed by the governor, previously approved by the Senate in New York. It sets a 25% cap on financing companies' gross recovery from a lawsuit and has other restrictions and provisions that are of interest. Let's talk about litigation funding for those of you who may not be familiar. Now, I spoke on a previous episode of this very podcast about why it's so hard to find a contingency lawyer willing to take a business litigation case. Because of that, there are a lot of times where people have good business-related claims but can't afford to go to court, can't afford to hire an attorney to prosecute them. Litigation funding is in part designed to address that. Now, litigation funding is sort of like a loan, but sort of not like a loan. The way it's like a loan is that a litigation funding company will advance you money that you can use to pay your lawyers and pay other expenses like expert witnesses, court fees, discovery costs in litigation in order to pursue your case. The way it's not like a loan is that, generally speaking, it is non-recourse. That means if you default on the loan, they can't come take your house, they can't garnish your wages, they can't collect it from the bank account. Either that litigation is resolved by a settlement or a judgment and collection and therefore generates money to which the lender is entitled to a portion, or it doesn't, in which case the lender is out of luck. And that means, of course, that generally speaking, litigation funding companies have to be extremely careful about what kind of cases they fund. They don't fund cases unless they think the claims are really good, the plaintiff is really good, and the defendant has money. I can't emphasize that last one enough. If this is not a case against a defendant who has money that you can recover after a judgment, a litigation funding company won't touch it. But when you have those three things, a good case, a good plaintiff, and a defendant with money, a litigation funding company can step in to help finance. There are good things and bad things incumbent with that. The good thing is it allows people to pursue cases that otherwise they may not have been able to pursue. It can level the playing field where there's a consumer plaintiff going up against a big company trying to recover on some business dealing that went awry, and the consumer doesn't have money and the company does. Litigation funding can even that playing field, get everybody into court where the dispute can be resolved. Now, it has been criticized. It's been criticized for bringing too much litigation and even frivolous litigation. I don't know that I necessarily agree with that. And it's been criticized because sometimes the litigation funders take a very large portion of the recovery. And you have to understand this from the point of view of the litigation funders. They are investing in cases, so they invest in a bunch of different cases. Some of those cases pan out, some don't. And the economic of the litigation funder is that they have to charge a lot in the cases that do pan out to justify making those investments in all the cases. Obviously, they only try to pick winners, but if you know anything about litigation, you know that not every winner you pick will end up being a winner. Because of that, a litigation funding company has to diversify its portfolio, it has to spread its risk, and it has to charge a lot of money in the cases that are successful. And I've seen contracts where a litigation funding company wants to advance an amount of money, let's say it's $500,000 to fund the cost of litigation, and then looks to collect 3 times that or more if the litigation is successful. And you can end up in a situation where you settle the case for a couple $1,000,000, and the litigation funder is going to get the bulk of that. And that is part of what this New York bill is designed to address. So let's take a look at the bill itself. You can find it online with a very simple Google search, but this is the bill that was in Senate at the beginning of the year and has now been signed by the governor. The legislative intent, it says, in an effort to promote consumer protections related to consumer litigation funding transactions, this act establishes that such transactions should be subject to state regulation and sets forth requirements regarding disclosure, licensing, funding company and attorney responsibilities, and limitations, violations, and other items. So what they're trying to do is protect the consumer. The Act, as most of these do, defines its terms, advertise, charges, consumer litigation. One important definition here is the definition of consumer, a natural person who has a pending legal claim and who resides or is domiciled in New York. So this bill only applies to litigation funding to human beings, consumers, and only if they live or reside in New York. Okay, jumping down to the first provision, there are new requirements for consumer litigation funding contracts. They have to be written in a clear and coherent manner. They have to be completely filled in. They can't have any blanks when they're giving to the consumer. They must contain a 10-day window for rescission, and that's meaning a cancellation provision that it can be canceled within 10 days of being signed, and that's got to be in bold 12-point font. It's got to be initialed by the consumer on every page. It has to have a statement about fees and charges. It has to have further disclosure as enumerated by the Act. Next, the contract has to contain a written acknowledgement by the attorney retained by the consumer in the legal claim attesting to a number of issues. And the reason for that is to promote a discussion between the consumer and the attorney and to make sure that the consumer really understands the contract. So the attorney has to acknowledge it. The attorney has to review the mandatory disclosures. It talks about the attorney's acknowledgments of how the proceeds are going to be distributed and dispersed, and that the attorney has not received a referral fee or other consideration from the consumer litigation funding company. In other words, the litigation funder and the attorney can't secretly be passing money to one another. Everything has to be upfront and spelled out in the contract. If the contract doesn't have the required disclosure, the required attorney acknowledgement, it is null and void. So no litigation funding company is going to advance money unless the attorney has signed off as required by this act. There are prohibitions against litigation funding companies paying or offering to pay commissions, referral fees, or other compensation to the attorneys, from accepting commissions, referral fees, or rebates or other compensation from the attorneys, from false advertising. Significantly, there's a prohibition on any litigation funding company receiving any right to or making any decisions with respect to the conduct of the underlying legal claim or any settlement or resolution thereof. The right to make such decisions shall remain solely with the consumer and the attorney in the legal claim. They want the consumer and the lawyer deciding settlement and strategy, not the litigation funding company. Then it says an attorney or law firm retained by the consumer in the legal claim shall not have a financial interest in the consumer litigation funding company. So if you're a lawyer, you can't own a funding company and have that company entering separate transactions with your client. The attorney itself shall have no financial interest in the consumer litigation funding company. The attorney may only disclose privileged information to a consumer funding company with the attorney may only disclose privileged information to a consumer litigation funding company with the written consent of the consumer. There is a further section on prepayment that talks about how you can have prepayment in a consumer litigation funding situation. It will be a predetermined amount based on intervals of time. In other words, if the advance from the consumer litigation funding company is paid before there's a settlement, before there's a verdict, before there's a judgment, the amount to be paid is going to have to be based on the amount of time that the money has been out. It can't be based on the amount obtained. The law requires numerous disclosures to be made by consumer litigation. On the front page, under an appropriate heading, they have to disclose the funded amount to be paid to the consumer, an itemization of one-time charges, maximum total amount to be assigned by the consumer to the company, a payment schedule, all of that right up front. The right to cancellation and rescission has to be there clearly, and it goes on with other disclosure requirements that you're going to have to take into consideration if you do one of these transactions. There's a whole filing requirement by litigation funders with the New York Secretary of State, so they're all going to have to be registered in New York and to renew that every 2 years. They're also going to have to post a bond not to exceed $50,000, but they're going to have to post a bond to do business in the state. Okay, here's the key provision. Section 5 here, provided the consumer's attorney or the consumer provides the Consumer Litigation Funding Company with an attestation disclosing the final amount of the gross proceeds from the claim, the maximum allowable charges shall not exceed 25% of the gross proceeds from the applicable legal claim, regardless of the funded amount provided for the relevant claim. 5% is the cap for the litigation funding company. I'm going to get back to that in a minute and talk about how that's going to impact the whole landscape here. One other provision I want to highlight is 899-333, effective communications on privileges. This section provides that all communication between the consumer's attorney in the legal claim and the Consumer Legal Funding Company, as it pertains to the consumer legal funding, shall fall within the scope of the attorney-client privilege. So let's talk first about that privilege provision. This is going to settle some debate that has been brewing in the consumer litigation funding arena since it began, whether or not communications between the funder and the client are privileged. And the reason that's important is because someone looking for funding may say all sorts of things about their case. They may say, my case is strong, my case has the following weaknesses, I have the following troubling witnesses, these documents are problematic. You might say a whole host of things that your opponent would like to find out. So sometimes opponents try to get into the communications between the consumer and the lending company in order to get to that information. And this act would actually settle that question in the state of New York by saying that if it's the consumer's attorney having a discussion with the lender, all of that is privileged. As long as you do it through your lawyer, as long as you have your lawyer talking to the lit funding company, anything they discuss should be privileged, and that's going to be very important. Okay, so let's talk about the economic impact of this act. There is a cap set of 25% of the recovery. And that's going to change a little bit the economics of this deal. The funders are still going to want to double their money or better for every loan they make that is successful. And what it means is they're going to have to look for cases where there is a smaller outlay for a bigger recovery. Let me give you an example. If the consumer wants $1 million to litigate a $5 million case, that's not going to work because the most that could be recovered by the funding company is 25% or $1.25 million. You're not going to want to loan $1 million in a litigation funding arrangement if you can only get $1.25 million back. If you loan $1 million, and I'm using high numbers, a lot of these consumer cases are smaller numbers. I tend to work more with the business funding cases. We'll get into that in a second, where the numbers are a little bit higher. But if you want to borrow $1 million to litigate a case, you really need something that's maybe going to recover $10 million or more, because at $10 million, the funding company could get $2.5 million back. They might be willing to loan $1 million for a return of $2.5 million, depending, of course, on all the other things. Is the case any good? Is the plaintiff any good? Is the defendant any good? But it's going to impact the economics. Remember, too, that the attorneys generally have a financial interest. Now, they are taking some of that money that's being advanced. The whole point of the litigation funding is that the client uses it to pay the lawyers. But typically in these deals, the lawyers accept a reduced fee and they look to get back the missing portion if they're successful, and sometimes a success fee on top of that. So the lawyers have a partial contingency, which also has to be paid out of any success. This law doesn't, to me, seem to limit what the lawyers can earn on their partial contingency deals. So the deals will be structured in a way where litigation funding companies will be looking for plaintiffs who have high amounts of potential recovery, and they're going to ask the lawyers to take even bigger portions of the risk so that more of it can come back to the litigation funding company in the event of success. In my experience, litigation funders are really picky about the cases they take. They only want to take cases they think are going to win, as I've said, and only with a good plaintiff and a defendant that you can get money from. So I don't know that they need to be incentivized that more. There's no point in advancing money in a litigation funding deal unless you think there's going to be some sort of recovery. I don't think this is going to change that landscape at all. Initial reaction to this act from consumer protection people seems to be positive. It's being hailed for providing clear contract disclosures. It's being lauded for providing a right to cancel that 10 business days. It has the attorney oversight provision, which I do like, requiring attorneys to review that the mandatory disclosures have been made and that they have to sign off on the deal and they have to verify that they don't have any separate financial interest in the arrangement. I think all of that is good. I think it's good to have clarity that the litigation funding companies shouldn't be actively participating in settlement discussions or strategy or driving it. It should be driven by the consumer, the client, and their attorney. And many like its registration and reporting requirements, having funding companies register with the state of New York, file annual reports, post bonds, make disclosures. All of that will keep a more active oversight of this industry. Now, lastly and importantly, we said this only applies to consumers. And there are many, many commercial funding transactions, litigation funding transactions where the plaintiff is a company. And this would not appear to apply to that. And that's relatively typical. We're more concerned about consumers being adequately informed and consumers making the right decisions than we are with larger companies. So that might also shift a little bit. I think the litigation funding industry is already heavily focused on corporate borrowers, but I think this will make it even more so. This is really going to impact smaller consumer litigation financing deals where there are individuals who are entering the transactions without really understanding what they're signing up for, what their rights are, and how much of the claim they're giving away. And to encourage that kind of disclosure and understanding, I think it's a step in the right direction. It has 6 months until it becomes effective, so I imagine more could happen in that interval. We'll see how the litigation funding companies react to it. I think I may be back to talk more generally about litigation funding. It's a very interesting topic affecting civil litigation, really has developed over the time that I've been practicing law, but is a very active part of civil litigation right now. But there you are for now. Kathy Hochul signs a new law in the state of New York. I hope I helped elucidate that. I hope I helped illuminate that a little bit. Enjoy your holidays. I'll see you soon. For now, we are adjourned.